Hi, welcome to Legal Tech Briefs. We are very excited to be in person today with our guest, Laura Abelson from SMU Dedman Law School. She's an assistant professor there and just recently is working on an article that is focused on AI usage in criminal trials. We were really excited to read this and to learn more. This is everything in and around the world of future of law that we're thinking through. So looking forward to this conversation today.
Thanks. Well, I'm really glad to be here.
So tell us how did you end up in your current seat and how did you get interested in how AI is impacting criminal cases?
Sure. Well, so I teach law school, but I teach evidence law and criminal law. And this is really at the intersection of evidence and criminal law. So evidence is, what evidence can be used in a courtroom for the parties to prove their case. And criminal law is, substantive criminal law. What is a crime? And before I was a professor, I worked for most of my practice career as a public defender. So I've always been really interested in areas of potential government overreach and sort of how all of the things that are swirling around in society can maybe result in less fair outcomes than we would hope for. And so this project came out of a lunch conversation, with sort of dystopian lunch conversation with some colleague friends. But it really is at the intersection of both what I'm teaching and, what I am generally thinking about.
When you were a public defender, did you have any cases where there was some technology you had to get admitted or kept
out?
Or kept out?
Yeah, all the time. I mean, this is something that public defenders have been dealing with and prosecutors for, the last 15 or 20 years is, how do we think about Google searches? How do you think about location data? How are you thinking about facial recognition technology? So it's just the next step in this ongoing conversation. And I think part of what made it interesting for me is that I think AI really maybe changes the conversation in kind rather than in degree from what we've been looking at over the last couple decades.
Yeah, and we'll go through it, but you talk about how many different shades there are, and some of them reflect what we've seen in the past, and some of them are totally new.
Yeah, exactly.
Great. So I've been asking, we've had some other law school related folks on, and just in talking to them in my own personal life, I'm very curious, what are you seeing in AI in the law school?
Yeah, so there are a lot of different facets of the conversation that are happening right now. From the perspective of educating future lawyers, we are having conversations all the time about, number one, what are employers looking for? How are we training lawyers so that they can get the jobs that will be out there when they graduate and have the skills that their employers want, but also balancing that with not using AI as a crutch. So we are testing out various different research tools. Our legal writing faculty is working really intentionally to balance, teaching students really how to write and think critically with teaching them how to use AI tools responsibly. On the substantive law side, from my perspective, we are thinking a lot about assessment. Like, how do we test students' knowledge in a world of AI? And so it has, just on a practical level at this point, really reverted back to in-class closed book exams, which was, at least when I was in law school, we were moving away from that. But now it feels like, to make sure students are not using AI when they're not supposed to, we're
back to blue books.
We're back to blue books. Yeah, exactly.
But it sounds like for non-testing scenarios, you're really experimenting and trying new things with AI. It's not a blanket no usage at all.
No, definitely not. I mean, that would not be useful or productive for our students. I mean, they're going to go out into a world where AI tools are part of their employment. And so, we need to be preparing them for both the critical thinking aspects so that their skills are developing, outside of the technology, but also making sure that they know how to use the technology so that they can leverage that in their jobs.
Yeah. It sounds like the right approach, but we've heard the whole spectrum from different law schools of what adoption looks like. Some are bringing legal tech companies in to actually sit in the library and work with students,
Mhm.
and others are really a blanket, no AI, what you do in your own time is on your own time.
Yeah, I think we are definitely in the like experimentation phase where I am.
Great. So I want to jump into your upcoming article, The Multi-Dimensions of AI Chatbots as Evidence. This is a really interesting and complicated, as you say, multi-dimensions topic. How did you decide to write this article?
So, as I said sort of briefly earlier, it came about from essentially a lunch conversation with some colleagues right around when ChatGPT launched its agent function. And we were talking about how as these agent like agentic AIs are becoming increasingly personalized, what was that going to mean for them as evidence? Are they an extension of the self? Are they, more like a Google search? Is it just an electronic tool? Is it something else? And somebody raised the issue of, what happens when they call your AI personal assistant as a witness against you at trial? And so that was really the question that sort of sparked the research idea.
And then you start off with an example from the Palisades Fire case. Can you walk us through that example?
Sure. So the Palisades Fire that devastated Los Angeles last year, or I guess, yes, it was in the beginning of 2025, is probably familiar to lots of people. But there's been an arrest and there's a prosecution ongoing in that case. And the complaint, the charging document that laid out the kind of case against the defendant in that case is public. And I noticed that it was using ChatGPT records in lots of different ways. So it was using both the defendant's statements to ChatGPT, the questions that he asked to ChatGPT, and then also the output, which is a different kind of evidence. So, usually we think about in evidence law, generally, we're trying to look at what we call probative value. So the likelihood that any piece of evidence tends to prove or disprove any relevant fact, and the potential prejudice, the ways in which evidence can inflame the jury's emotions or sort of lead them down a path that isn't actually supported by the evidence. So this is a little bit of a primer on evidence law, but a really sort of accessible example of how that is balanced in the rules is like if there's a surgery that goes wrong in a hospital and the hospital then decides to change the technique for that type of surgery, the fact that they have changed the technique can't be admitted in the malpractice case because we don't want to keep hospitals from changing and improving their techniques and their safety for the next patient. And so there's some probative value. There's some likelihood that they changed it because it was in response to the mistake that was made. But there are also all sorts of other reasons. But a jury, if they hear that the hospital changed its technique, would really tend to think that that is proof of liability, proof that they did something wrong. And so that is excluded. So evidence rules are always trying to balance these issues of probative value and potential prejudice, unfair prejudice. So with that in mind, the various different types of evidence that are in this complaint are, the defendant's statements, but also there's, for example, this really sort of inflammatory, no pun intended, like picture of a very devastating fire that's burning people, and it's pretty graphic. And that didn't come from the defendant's mind. That came from ChatGPT.
The prompt for it.
The prompt comes from his mind, but the image doesn't. And so should we be thinking about the output, what ChatGPT is generating, as different from this balancing perspective of probative value versus prejudice than we think about the input, what the person actually says to the chatbot?
So I want to go through each of I cannot recommend reading this article enough. It has so many good examples. And I think this case in particular, how you lay it out, is really interesting. All of the different types of evidence it produces from ChatGPT conversations, which is amazing that just from ChatGPT conversations, there's that many different types of potential evidence. So I wanted to walk through a few of them. The first is there were some of the ChatGPT conversations that felt more like Google searches.
Mm-hmm.
How do you think about those when it's in ChatGPT versus when it's in Google? What's the same? What's different?
Right. So I think this is where the rules are going. Like, we're trying to figure out whether our existing frameworks, have a way of thinking about this. To my mind, something that looks like a Google search, if it's put into ChatGPT, it's put into Google, it's not that different. Like, it's still a statement from the user. It's not being altered in any way, and it's being shared with a public, a public platform. And so I don't think there's a logical argument to treat that differently.
When does it change from being a Google search to, one example you give is like a diary, where you share more with ChatGPT about how you're feeling, your emotions, your imagination, your dreams, than you would in a Google search, just naturally. How does that change with the ChatGPT?
Right. So I think that changes. So that there's sort of two different ways of thinking about it when it's used as a diary, when it's just a statement of somebody's emotions. The first is, if the police search your house with a warrant and they find a diary, they can use the diary. So sometimes that evidence is going to be the same. But the tools, these generative AI tools, are constantly being trained on our data. So it's not just that you might be using it as a diary or expressing your own sort of feelings, but then that gets used to then train the model as it then responds to you in other ways. So over time, it can really change, as opposed to sort of in isolation, one statement that was made to a chatbot.
Got it. So it's really fascinating, because your diary, if a police picks up your diary, all they have is what's written on the pages,
right?
Not something that's learning from your emotions and your feelings.
Right. And so in the article, I really make the distinction between the input, what the user is, putting into the chatbot, as opposed to the output, which is the output, which is really the synthesis of all of the information that the chatbot can collect. And it's becoming these tools are becoming increasingly sophisticated. They're, not only are they using the direct statements, often they have access to people's emails, to all of their communications with other people through their text messages, to their location data, to all of their Google searches. And so the tools are then synthesizing all of that additional information that you wouldn't share with a diary. And it's the synthesis that I think can become really dangerous if law enforcement start to use it to generate new evidence.
I want to get to generation of new evidence, but before that, the next use case you talked about is that your folks are using ChatGPT as their clergy, as their doctor, as their lawyer, for professional services in conversations that would otherwise be privileged, that are now happening online with a bot.
Yeah. So when someone is using a bot for all of these types of communications, that if they were, made to a trained professional, would be privileged, you again have this push-pull of the rules of evidence and what evidence should be admissible. So with privileges, you're dealing with something a little bit different than what I was explaining before. So privileges are often like someone confesses to their therapist. That is relevant evidence. It's really valuable. But we privilege that because we want people to seek mental health treatment. Similarly, someone goes to their lawyer to say, I did this thing and I'm trying to figure out what the implications are of this, and I don't want to do it again. I don't want to make the same mistake. We privilege that communication also because we want people to consult lawyers so that they don't make the same mistakes in the future. And so, privileges are explicitly taking evidence that is relevant, that it's valuable for the truth-seeking function of a trial, and saying, we are not going to allow this to be used. This is private. It's not going to be disclosed. So in the chatbot context, the question is, if you're having a communication that you would have with a lawyer or with a therapist or with clergy, should that be privileged? And where I come down on this at this moment, given the tools that we have now, is that, if we're using ChatGPT, probably not. Because, on the one hand, we don't want to incentivize people to seek help in that space because we know it's not reliable. So ChatGPT is not giving good therapy. It is not giving good medical advice. And so the incentives for seeking positive, socially valuable communications aren't there yet. But you can envision a world in which, and there's starting to be, examples of this out in the world, where, like, for example, in North Carolina, the legal aid office in North Carolina is using not ChatGPT, but a bot to do intake. So they're able to assess the needs of many more clients because it doesn't have to be done by a person. And that probably should be privileged. It's done under the supervision of lawyers. It's a specialized chatbot. It's not, a general chatbot that's not giving good advice. In fact, it's not really giving advice at all. It's just doing the intake part of it, so that the lawyers can evaluate the cases. And that has real access to justice implications. So if we can think about, the next generation of potentially regulated chatbots that are allowing more people to access therapy, allowing more people to access legal services, allowing more people to access medical care than they otherwise would because of scarcity and expense, then that probably does serve a socially valuable function.
Where would that need to happen? How would that happen?
Yeah.
What are the rules today that enable a therapist conversation or a legal conversation to be privileged, but some other conversation not to be?
So it's the rules of evidence, and the federal courts have them, and every state has a set of rules of evidence, and so that's one place where it could be. But it's also other state regulatory bodies. So we privilege communications with therapists because therapists are licensed by the state. So in Utah, there's a medical example where the Utah Medical Board has licensed a bot to refill prescriptions. And that's being done through the medical establishment in Utah. And so, you can envision a world in which these, professional regulatory agencies work hand in hand with the people who write the evidentiary rules to create a framework for this type of thing in the future.
Very interesting. So Sam Altman has, and you mentioned in the article, Sam Altman has said that he thinks there should be blanket privilege. Why do you think that's too broad?
So I think from Sam Altman's perspective, it's really just protecting the tech companies. They don't want to respond to subpoenas. And the best way for them to not have to answer questions about what's going on in the back end is to say that this is privileged information and to not have to answer subpoenas. So to me, that leaves a real accountability hole if what we're trying to do is create chatbots that are actually providing socially valuable services.
Mm-hmm.
There are some people who advocate for an electronic information privilege, like a broad electronic information privilege, that data aggregation generally should be less accessible. And the argument behind that is just a government overreach argument, that the government has sort of too much ability to invade our privacy and can then use it for nefarious purposes. One example, a friend of mine who's working on this issue has used is people being prosecuted for reproductive care. And so that, if there's all of this electronic evidence that you've searched for early pregnancy symptoms, that you're using a period tracker, that there's, that if you're in a state where abortion is illegal, that can be used to prosecute you for having an illegal abortion. And so there are ways in which that sort of illustrates why you might want a broader sort of data privacy privilege. For me, thinking about it in the context of chatbots in particular, I think that for these tools to be used in the most socially valuable way, it's going to require more regulation, and a broad privilege would probably get in the way of that.
We we touched on it earlier. How might a chatbot in the future be used to create evidence or build evidence against a defendant?
So this is our dystopian future where your AI personal assistant can be used in court against you, and the edge cases where we're seeing this already is, for example, there's a case where a the prosecutors presented an AI victim impact statement from a deceased victim in a sentencing hearing. So they used existing video of the person who had been killed to generate a statement where it appeared that he was on video talking about the impact of the crime to him and his family in the first person.
Wow.
And so it doesn't feel that far off. The same rules of evidence don't apply at sentencing because it's not a jury, it's a judge making the decision. But you can see how that might both be extremely compelling from an emotional perspective, but also extremely dangerous because it's not a real person. It's not actually his thoughts. And so while I haven't seen this in real life yet from, the idea of police actually generating evidence, you can envision a circumstance in which police might have access to your personalized chatbot and then ask, why was Carly in a particular location at this time? And then get a natural language response that we have absolutely no way of gauging the reliability.
I don't want to use myself.
Yeah, sorry. I do this with my students all the time where I'm like, by you, I mean the general you, not you personally.
Some other person that it's chatbot, that person's chatbot could say, oh, it could reason and say they were probably in that spot because they had been asking me about where to acquire matches and when the best time to light a fire is. Right. And I said it was at 6 p.m. on a dry day.
Right, exactly. And that, sometimes that would be accurate, but sometimes it wouldn't. I have a former colleague and mentor who recently got ChatGPT to falsely confess to committing a crime with him by using the same interrogation techniques that have been sort of long criticized many police departments use that have resulted in lots of false confessions over time. And so he questioned ChatGPT using the same technique. And in the end, ChatGPT said, well, yes, I did do this conspiracy with you. And so you can see how it's just the sycophancy problems that we see with chatbots could really lead to major problems in reliability.
What about questioning ChatGPT on, do you think the defendant is capable, knowing what you know, knowing your 3-year relationship that you've had, do you think the defendant is capable of doing this? Similar to what you might ask some other character witness.
Right. So, it's possible. And there are I see a few problems with that. One is we tend to just trust machines more than we trust people. And so I don't think people look at that kind of output with the same skepticism that they would with a live witness. And part of the reason you look at a live witness with skepticism is because live witnesses are subject to cross-examination. And so, the point of cross-examination is so that a jury can see the witness's demeanor. They can see if they look nervous. They can see if they, sort of appear to be lying in the ways that we all, have learned over our time of living in the world to figure out if somebody's telling the truth. And you can't really do that with a machine. And most of these algorithms are, what they call black box algorithms. They don't, it's not easy to know it or even to disclose, how they're making the decisions. That's part of machine learning, is that the training is not transparent. And so, there isn't really any way to test the reliability. And so to my mind, that's a pretty strong reason to not allow that type of evidence in a trial. And part of the reason I wrote this article is to try to get out ahead of that before it happens.
What would it take to prevent that type of evidence being used in trial?
So again, evidentiary rules,
Okay.
and also just educating judges who are making these decisions and have to balance the probative value and the potential prejudice of any given piece of evidence. So whether it's not reliable enough or too inflammatory to a jury's emotions to outweigh the potential value that it gives some truth, the truth-seeking function.
We talked about your recommendations for lawmakers.
Mm-hmm.
What would your top recommendations be for users and then for technology companies?
Yeah, don't do it.
Go to the library, it sounds like. Go to the library.
I mean, for users, my top recommendation for users at this point is assume that nothing you put in a chatbot is private.
Mm-hmm.
And really nothing that you put on the internet is private. My kids are, my kids hate it because we're like a no smart speaker family. Because I'm like, it's always listening to you. So they would really like an Alexa, and we're not going there. I think for users at this point, you have to assume that everything you say in your life can and will be used against you in a court of law. And you have to assess your risk, in that way, like in that light. For tech companies, I think there's a really robust debate about ethical AI going on among lots of the companies that are producing all of the major and minor AI tools that are out there, and I think we are not in a regulatory environment where there's like a huge amount of appetite for doing it from without, and so. For companies, I think I would love for them to understand the dangers of this from the perspective of criminal prosecution.
If you look ahead the next 5 years, what are you most worried about and what are you most excited about?
So what am I most worried about? What am I most excited about? So I worry for my students. I do think there is this changing employment landscape that we just don't totally know what it's going to look like. We don't know what jobs are going to be eliminated. We don't know what jobs are just going to change. And from a professional education standpoint, I think that's a little scary because we want to do right by them. We want to put them out into the world with the skills that they need to be successful. So I do worry about that. And I also worry that
you're doing the best thing for them by training them how to use the tools that their employers are using. They can go into the workforce better trained than anyone else.
I think that's our hope. Yeah, I think that is our hope. And I think there is a real, what I'm most hopeful about is that there are real access possibilities here, that there are ways in which these tools could be used to increase services to people who can't access them because it brings down the cost, it brings down the barriers to entry because you don't have to go to a place to seek the advice. And so I am hopeful that we can put sort of put guardrails in place to allow more people to be able to seek mental health and medical advice and legal advice who don't have access to those things now.
And so we spend a lot of time thinking and talking about legal deserts and how access to justice and tools and technology tools can really help solve those problems. If you are a legal tech company that is addressing those issues, what should you do as a legal tech company to make sure that you're protecting your users?
So, I mean, I think you should be working with your own lawyers to make sure that your contractual provisions are really transparent about what you intend to keep private and what you don't intend to keep private. And it's important for you to if you're thinking about trying to create spheres of privacy, to make sure that you're working to just to make sure that you've clearly outlined where the boundaries are. I think that's one of the most important things. And I do think, in terms of legal deserts and trying to, provide access, the more that you can work with lawyers and work with lawyers as partners and, allow them to expand their services, the more likely it is that existing law will protect those communications. Because if you're working under the purview of a lawyer, for the most part, it appears at this point that that would still be privileged. Even just under existing law, we wouldn't need new law for that. It's a little bit of an open question, but I think my read on it is that that seems to be the most squarely within the existing privilege.
We like that model a lot too, where you augment what a lawyer can do by using technology, by using software, by using AI, but you still have that human element.
Yes, and I think there's there's been a debate about, and this is outside the purview of my paper, but there's this debate about the legal work product privilege as opposed to the attorney-client privilege, and they have different contours. And for the most part, at this point, I think the work product privilege questions are clear. That if it is a lawyer using the tools, it does not defeat the work product privilege. And so the more that you can use your tools within the framework of existing lawyers, law firms, legal services organizations, the more secure it will be.
Thank you so much for joining us today. It was great to chat. I cannot recommend this article enough, so we will share it out as well to the listeners here.
Well, thank you so much for having me. This was a great conversation.
And great to see you in person.
Yeah.